Ms. Scott, since the burden lies with the state of Ohio is entitled to a final rebuttal argument. Mr. Tiemann, you may address the jury.
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen of the jury. Again, I'd like to thank you for the patience, the attention, and the overall service you've done in this trial. On behalf of the state of Ohio, we appreciate that justice could not be done without our citizens doing it. I just want to point out a few things from what we've heard, and you guys have paid attention, so I don't need to go through each and every detail. I'm not going to spend a lot of time telling you specifically what other witnesses said. You heard what they said. You know what they said. You don't need me to tell you or anyone else to tell you what they said. There was some to-do made about the growth of the baby, and it was such a low growth that the baby must have died on March 28th. I don't think there's any scientific evidence that you can point to in this case to make you reach that conclusion. As a matter of fact, the state of Ohio doesn't even have to prove the date of death. The judge will instruct you on the date of death and venue as part of those instructions. I've also heard that Jessica Groves has taken the blame for everything that happened to this baby. Of course, she didn't say it was an accident, and when inquired about exactly what happened, she wouldn't tell us. So a few things I'd ask you to take into consideration. I'd ask you to consider the credibility of the witnesses. Consider the evidence for the multiple changes in stories of some of the witnesses versus the consistency of others. When you're considering credibility, consider all the witnesses together, separately, and the circumstances surrounding each witness, their motive for lying, their motive for telling the truth, what things would affect their credibility. And I appreciate it being pointed out that we look at circumstantial evidence as well as direct evidence. So there was no direct evidence or circumstantial evidence of these folks doing this crime. We had the son testify about seeing the bruises. We had a baby put down a well and chained together in that. You're allowed to make reasonable inferences as to who killed this child. Again, we don't have to prove the date of death. And it was indicated that some of our witnesses weren't necessary. And you know, back in Vladar on Monday, I promised you I would take as long as I needed to and not a second more. It was necessary to establish a timeline to provide you with the information of when this baby was healthy, when this baby was thriving, and then when this baby died. So for that and that alone, we had to go through the sequence of this baby's short life. I would submit to you that the evidence is uncontroverted that one or both of these defendants acted as the principal in the killing of their baby Dylan or complicit therewith. They were isolated out there. There was no other evidence that anybody else did it. There was no evidence that anyone else caused these injuries except one or both of these defendants. There was a lot of issue in the trial about safety plans versus case plans. whether or not Daniel was high, whether or not he faked a drug test, whether or not he had clean drug tests. I would submit to you that whether or not there was a safety plan or a case plan, whether or not, regardless of those plans, regardless of whether they were high or not, if Daniel were stone cold sober throughout this entire process, they were the parents of Dylan Groves and had a duty to act to protect this child. They had one job: parent up. Protect your kids. 3 times, at least, our medical expert testified that 3 times this child, Dylan Groves, was the victim of blunt force trauma. Blunt force trauma violent enough to first cause broken ribs, then later a 2-inch fracture to his skull, and after that, one more set at least of violent trauma to again fracture his skull, to fracture the bones in his arm and his leg. In the rib fractures, our experts said there were signs of healing. The signs of healing in the rib fractures were significantly more than those in the skull fracture. And then the other skull fracture in the arm and the leg, there were no signs of healing, which was indicative of those fractures occurred shortly or contemporaneous with death. The expert also pointed out from those earlier fractures, and you saw the pictures, there was bruising on the abdomen, and it was either decomposition or bruising around the top of this baby's skull. The doctor, who didn't see the baby, of course, until the baby was in her care at Montgomery County, didn't have the benefit of seeing what Daniel Jr. saw. And Daniel Jr., one of the bravest kids I know, got up there and testified and said he saw bruising and swelling all over the skull. Ladies and gentlemen, we do have the burden, and you have to be firmly convinced of the truth of the charges to find these individuals guilty. We didn't ask you to leave your common sense at the door. Common sense is part of considering reasonable doubt. How many times would this baby have had to been violently dropped or struck to cause these injuries? If the baby had a broken arm, could that have been an accident if that was the extent of the baby's injuries? Maybe, maybe not. That's an entirely different case. But all of these injuries together in such a relatively short time, whether it's days or weeks, is that an accident? Does your common sense tell you that's just an accident for a 2-month-old that can't roll around, that can't climb a tree, that can't ride a bike? Is there any way those were accidents? What's your common sense tell you? Again, we don't need to establish who the principal is. The judge will instruct you. But you may think Jessica Groves is the principal because of that sterling, highly detailed confession she made from the stand. And I'm being sarcastic when I say that. Certainly, For whatever reason, she wants you to think that. And if you think that, that's okay, but I would also submit to you that Daniel Groves Sr. facilitated the death of Dylan by giving Jessica Groves the means and the multiple opportunities to kill that baby. When Dylan didn't die from the first set of injuries, when Dylan was shaken in his mother's arms, when a 2-month-old baby, Dylan, was struck in the head or hit in the head or slapped in the head, none of which are appropriate in a 2-month-old, 4 times. Did Daniel call 911? Did Daniel call Children's Services? Did Daniel go to the neighbors? Did Daniel call Andrea Bowling, who provided a number for him if he ever needed anything? Felonious assault is act or failed to act. Complicity is giving somebody the opportunity and getting them out of the way. He failed to act to save this baby when any other person in this courtroom would have easily seen the writing on the wall. But he was scared. He was scared of his wife. Truth is, he chose his wife over his baby. A broken promise. Not only did he fail to act, he took every opportunity under the sun to mislead all the agencies that were out there to help him. And you may have issues with one agency or another on what they did or didn't do, but they're not on trial here today. These 2 individuals are. The parents who murdered this child. Took every opportunity to mislead and conceal the potential dangers to the life and safety of Dylan Groves. So whichever way you want to believe, by whatever method, Daniel Groves and Jessica Groves' actions and or their failures to act caused serious physical harm to their baby Dylan Groves, caused his death, murdered their child. Ladies and gentlemen, it's up to you. You are ultimately the one who has to decide whether the state met its burden. You're allowed to find them guilty of separately and individually all or any or none of the charges. I'm confident after you consider the evidence that you will find each defendant guilty as charged to each and every count of the indictment. We're done talking. It's time for you to deliberate, and we appreciate your service. Thank you.
Thank you, Mr. Chairman.